So before we move on, I'm sure that everybody wants to know the answer to this question. Anything that outside counsel does that really irritates you along the lines of trying to, force feed the individual accountability Yates Memo that could be a learning instructed for some of us that you want to say?
Yeah, maybe this is just a general comment, maybe not as specific to Alice's question, but...
Or not specific to Alice. Whatever she's
not specific to Alice. What we're looking for is true partnering guidance and helping us assess the facts and assess the law. But sometimes, because of Yates Memo and other things, it's well, you've got to do this. And we may come to that point, but we need to really have a thoughtful partnering assessment to make those determinations. And again, I think we've all talked about all of us want to cooperate. It may not be the fulsome all cooperation, but we are interested in resolving the issues internally and cooperating with the process externally. But to sort of say, this is the path early in before even the external counsel knows all the facts is not always helpful. So somebody that is measured and thoughtful and is really thinking through all of the implications for us is really what at least I'm looking for.
I agree with that, yes. I've had that situation, unfortunately, where I've gotten off a phone with an outside lawyer, explained and had a good back and forth about where we really were in the course of events. And it wasn't, a huge material matter. It was something that, one business unit did, that it was just a question of when to go to the government, not whether. And I thought he had understood it, and then I get an email sent back to me saying, well, I've talked to some other people, and you must go forward and self-report. And to which I said, I called them because I don't do trial by emails, and said, we just had this conversation. I don't even know what to report yet. You haven't given me the information. And I'm not going to go in prematurely until I have a good handle on it. So I think that, as you said, look, if you have some material investigation, you need the full gamut of team players. You need good outside counsel who can be practical and respond to each and every new development and help you, advise you as to what's likely coming as the next step, where this is going. You need good internal support, because one of the things that I think GCs depend on is being linked up with other internal bodies, compliance obviously, but also internal controls, internal audit, because sometimes it's the mix of all information that you need. And we depend on good forensic outside people too, because they can do things, with all due respect to a legal crowd, that lawyers can't do or can't do very effectively or cost effectively. And so you really need the team approach, which means nobody dictates to anybody. You listen and have a good dialogue about it.
I would just add that the one thing outside counsel is always going to have an advantage on is you are external to the company, and you represent a lot of different clients. And I know we have always valued that external point of view, and we want it straight. If Tenet is taking a position that is way on one end of the spectrum or another, we really want to know that. Obviously, we don't want disclosure of any client confidences, but we want a straight shooting, objective point of view, recommendations with options. And I often feel like, as you can tell, there are a lot of competing interests here. The board, today's investigation, tomorrow's shareholder litigation, individuals, their counsel, company counsel, a lot of competing interests here. I oftentimes feel like my job is to represent the situation, while obviously respecting my strong ethical duty to represent the company and the interests of the shareholders. And I really need somebody that can partner with me to do that and help not pick a side or an interest, but really lay them all out, let us look at them objectively and make some recommendations that are measured, to use your words.
Alice, you asked for petty, right? Petty annoyances?
Have at it, Audrey.
Hypothetically, just between us, there was an outside lawyer representing one of our executives in a criminal probe that was declined early on in my being a general counsel on a factual finding in the DPA that exonerated all employees of any criminality at all. And the exoneration, which was public, said that particular lawyer's client had been negligent, not criminal. And after the completion of the publicity, we got a very strongly worded letter from that lawyer saying it was outrageous that his client was maligned and called negligent. Now, I might have had a strong reaction to that, but I didn't, because before I saw the letter, our outside lawyer had gotten the letter the day before and had already responded. This is the part where a lawyer for someone who took 5 in the grand jury should say thank you for the non-prosecution. That was a petty annoyance. The rest of it, you can handle over time, as annoying as it is. Yeah. But I was focused on the petty annoyance.
Yeah. So we're going to move on to kind of some of the other things that the department has been doing, and this in the area of compliance. So the fraud section at the criminal division has hired a compliance expert to evaluate companies' compliance policies and procedures when a company is being investigated or heading towards resolution or heading towards a plea to not have a resolution with the department. In addition, I think maybe 10 days ago, maybe a little bit longer, the criminal division set out some guidelines for compliance, basically speaking on what kind of questions that their compliance experts will ask within the fraud section at the Department of Justice or within the criminal division at the Department of Justice. And it's 8 pages. It's very lengthy. It's very detailed about how a company should be setting up its compliance protocols. It includes things like what kind of training should be done, what kind of discipline should be done, what kind of collaboration, who the compliance person can report to. And a lot of this is things that you can pull together from the sentencing guidelines and other guidance out there from HHS and other things. And it's great when the department speaks and lets us know kind of what they're thinking. But what do you think of this trend with the Department of Justice really saying so much about what compliance should be?
Sure. I come from the healthcare perspective where we've had very detailed, 8 pages is short. In our world, we've had very, very detailed, very explicit guidance on the actions and steps to take to have an effective compliance program in all different segments of the healthcare industry. So I actually thought it was very refreshing to see the Justice Department, Wei Chen, the Compliance Counsel that they hired back in November of 2015, pose it in a series of questions that a company should be asking itself, as opposed to a more defined, these are the things that you have to be able to check off in order to receive full credit for having an effective compliance program or partial credit for having a partially effective one. So I thought it was well done and helpful. I think part of the reason I had that reaction to it is because whenever you're in the middle of a government investigation or some type of litigation with the government, litigation or an investigation can be a great teacher. We try and do look-backs on every case that we have, whether it's government or anything of any substance, because it really does show you where you may have gaps in your process. And if you're serious about closing those gaps, you'll do that. It's a great teacher, but the challenge that you have if you're just working with the lawyers in the Justice Department that are leading the investigation, if they're the ones that are doing the assessment of the compliance program, what they're seeing is your compliance program through the lens of where the arrow made it all the way through to cause harm. So we talk in healthcare a lot about the Swiss cheese model, and it's, I think, a good compliance analogy. Every compliance program doesn't usually just have one safeguard to try and prevent harm from being done to patients or customers or the federal programs, but they have multiple layers. But we all know, at least, and I'm a recovering compliance officer, I don't think I'll ever fully recover, but we all know that every safeguard is really like a piece of Swiss cheese. It's got holes in it. And your job as a compliance officer and general counsel is to try and find those holes, shrink them, and keep them as small as possible. but I think we all appreciate that they will never be completely fail-safe. And if the ones that are handling the investigation on behalf of the government are the ones also assessing the effectiveness of those slices of cheese, if you will, all they're seeing is the whole. They're not looking at what else is there. And the company is also looking at it, but the company has more perspective on the other components of the safeguard and where you might shore them up a little bit through remediation to try and shrink those holes. So I think it's tremendously beneficial that they've brought Wei Chen into the role. She has criminal division experience, she has pharma experience, banking experience, she's been a lawyer, she's been a compliance officer, and she has that skill set to be able to make those assessments, but she's also not just staring at the whole. And I think it gives the company a better opportunity to have a conversation about what is working and the steps the company's willing to take to address things that might need to be tightened up a little bit.
Andrew Weissman, if you're out there, you just got your commercial.
Counterpoints? I'm probably the only one that feels that way, so.
Maybe I'll give a little bit, I don't have a counterpoint per se, because I think the notion that the department is looking at somebody with industry experience to come in and assist with the evaluation of programs is a positive thing, and I think most of us would probably agree with that. I think this panel is probably a reflection of what I think may be the weakness. The current Compliance Council does have experience in more than one industry, but when you look at this panel and the industries that we represent and think about the compliance challenges that are just represented on this dais, they are vast and different. And so to have somebody who has not been in an oil and gas services company or dealing with a lot of international operations in the same way is going to have more difficulty assessing whether my program is sufficient. At the same time, somebody who hasn't been in the gaming industry would not really be in the best perspective to understand all of the myriad of what are the pieces of the Swiss cheese. So I think it's a good start, but I think it is just a good start. And I think really an interesting idea might be to have a greater partnership between industry and the Department of Justice, perhaps creating a panel. If we really want to have assessment of programs and think about them holistically, then getting broader perspectives and having that dialogue might be helpful. The other challenge that I have on the evaluation of compliance programs is I think we actually have it come too late, because it's only a factor in minimizing the actual payouts that might come. It's never a factor that companies get credit for when assessing the company's intent. The analogy that I would make is, we have seen over the last couple of months, unfortunately, there have been issues of law enforcement and issues with the community. But I think I don't think any of us have concluded that those law enforcement agencies are fully corrupt, or even that those individuals were intending to violate civil rights. I think in many instances, perhaps they were negligent, made bad decisions at the time, but we certainly aren't saying that those agencies are fully problematic. But the corollary for us is that is sort of the view that we come to, is that if there's an issue, it's a low-level person, the whole company is corrupt, and therefore the intent of those individuals is the intent of the whole company. And I would argue that when we're spending millions of dollars and trying to have the tone at the top, and our CEO is out there in every speech he makes, like in my company, where integrity is one of the key hallmarks he makes in every single speech to our employees, everywhere where he is in the company, and we're trying to do all the right things. None of that seems to be a factor in trying to evaluate corporate intent. So that's my other comment is good start, but perhaps it needs to be a factor that weighs in both parts of the equation.
I would offer a slightly different perspective. I think that the model which has been offered by the Justice Department, in all due respect, is one that's been jaundiced by bad actors. And so this idea that these companies need this big compliance program with all these people, I think the model that works is the one where all the business leaders are compliance leaders, as opposed to having compliance be this program on the outside of the business that's not integrated into the business. And I will tell you that one of the advantages we have as an airline industry is most of the compliance issues we have relate to safely and securely operating our aircraft, right? And that's an operational reality. And so our compliance people are the folks that are really operating and maintaining those aircraft. And it really works well. And the other thing I'd agree on is its tone at the top, right? Its tone at the top. That's, to me, what, if I were at the Justice Department, I'd be focused on really making business leaders our compliance leaders and making sure that there's appropriate tone at the top instead of building what really can, in certain circumstances, be perceived as a police department that's out there with their checklists and their badge. Because all that means is that people are going to kind of drift away from them because of the distrust. So in any event, in all due respect to you, Justice Department folks.
Well, I think it also means that, business operators, managers can to some extent say, oh, compliance isn't my issue, it belongs to the compliance
belongs
department.
elsewhere.
Can't do that.
And I think, no compliance department, no lawyers are smart enough to know the daily challenges that business people face, what keeps them up at night, which is the question I always like to ask. What keeps you up at night? And to tailor a risk program, particularly in a very diverse business, which has to hit at the local level, because you may have a conglomerate that combines oil and gas and healthcare and the whole gamut of financial service, the whole gamut of regulated industries. I liked the memo because I thought it summarized, and yes, 8 pages is a long summary for some, but it did summarize decades of what we've known the questions would be, and I think it summarized it in a way in a Q&A form that business people can read and understand and do a self-assessment. And so I think for that reason it's good. You don't have to refer them to the sentencing guidelines or the 2010 amendments when their eyes start to glaze over. But I agree, tone at the top is what matters at the end of the day. Having much earlier in my career been a part of an investigation, when one of the people being interviewed said, oh, I know Mr. X, the CEO at the company, would never tolerate this behavior, that's what you want to hear.
I think it has the potential to be a two-edged sword. On the one hand, I think it's great if the department is going to go into the space that's traditionally been that of the regulators, whether it be the OIG of HHS or it be the SEC, and evaluate substantively the level of compliance controls within whatever the accounting controls provisions are. I think it's great for the department to have the resource. If it's going to be a one-size-fits-all, which the memo tends not to indicate, that is the way that the February memo's structured, at least, it's not a one-size-fits-all. But if it slides into a one-size-fits-all, I think it's problematic because each of these industries that I was in, that they are in, have their own sets of challenges.
So here's another DOJ policy that's coming up. About a year ago, almost exactly a year ago, the criminal division had instituted a pilot project. Let's see, and this relates to disclosure for FCPA cases and other cases in the criminal division. If you come in and you disclose and you follow these guidelines and do a full investigation and you do it quickly, you're going to get a 50% reduction in your fine at the end of the day, which could be extremely substantial with the fines that are out there sometimes. So this is about to expire in April of 2017, unless it's maybe announced this week that it'll re-up. I don't know. But what do you all think about that? And should it be expanded? Right now it's just, at Main Justice, but should it be expanded? Is this a good thing? More clarity about the benefit of cooperation.
The fraud section had a lot of experience with this in the aftermath of the Antitrust Department's program announcement 30 years ago, plus. The fraud section developed a program for defense procurement cases. And indeed, the defense industry took substantial advantage of that program over time. This is one where the jury's still out. I mean, I've followed it while I was in. I'm following it since I've left. I haven't seen any reports of companies making public disclosures of, we've leapt into it, and though we're under investigation, we're hopeful because we've availed ourselves of this program. And since any of those companies that would have availed themselves of the program have SEC quarterlies due, you would expect that you'd read about it somewhere. So I, for one, will be very interested to see whatever report comes out before the expiration that argues either in favor of the program being renewed, against the program being renewed, or having the program take on some different life force. But that program at least answered some fairly consistent criticism that's been voiced here and elsewhere in the defense community about, and I don't mean defense procurement, I mean criminal defense community, that explaining in concrete terms the benefits of voluntary disclosures.
Monetary terms.
More,
Put your money where your mouth is.
more art than science and more Jackson Pollock than Michelangelo.
Anybody else have any views on that?
The only thing I'll add, I just think any incentive to self-disclose is favorable. Self-disclosure is not always the right answer in every situation, but when you're the one in there explaining to your CEO and your board why you think it's a good thing to do, they have this, I think, natural tendency to expect that there will be some form of credit given, because that, we've learned that since we were children. At least I did, and I think everyone did. So when you can articulate it more specifically and have more guidance up front as to what that's going to look like, I think it makes that conversation go better.
I think one additional comment that I would make, when you read through the memo, there is a little asterisk fine point, which is that you must commit to disgorge profits associated with any criminal activity. So, going back to my earlier comment, there's the predetermination that the action, you're sort of admitting or conceding that it's criminal activity, and then you're agreeing to disgorge profits. So it becomes an interesting dichotomy. Yes, you may get a reduction on fines, but it seems that then that drives the conduct that people might be willing to disclose to more sort of petite issues, which may not really be what the aim of the memo was trying to get to. So I think, again, if it's really to say we want more transparency, we want people to feel comfortable coming forward, particularly with small issues, so we have a dialogue with companies, then a novel approach might be to go as far as saying there's a certain amount of amnesty if you come forward with issues. But we haven't quite gotten there yet. So there's still this, it's a little bit of a carrot and a stick because of the disgorgement side of it. And so I'm not sure that it's quite reached all the aims that perhaps it was hoping to.
Could be the new memo of the new administration, amnesty, right? Doubt it, but it could be.
Hope springs eternal.
Yeah.